Hello, everyone. This is Ben Gerber, along with Chris Gifford. We are attorneys here at Gerber and Holder, and today we're going to talk about workers' compensation and third-party claims. And what that really means is when you have a workers' compensation claim, there are times when you can have a personal injury claim as well. A prime example would be if you were on the job and in a vehicle and someone hit you in that vehicle. You could have both a workers' compensation case and a claim against the individual that hit you. And Chris, what is the most common question you get when an individual has a workers' compensation case and a third-party claim at the same time?
Well, these cases can be very complicated and confusing for the client. And the number one question I typically have relates to medical care. Who do I go see? Do I go see the workers' comp doctor, or is there another doctor that the attorney who is representing me in my personal injury case wants me to go see? The way that treatment is handled as far as payment is concerned can be very different, where workers' comp pays 100% of your treatment, whereas in personal injury that may not be the case. And this can be very confusing and it can be very complicated. My response typically to a client who reaches out to me when there is a dual case is that I need to speak with the personal injury attorney so that we can make sure that we are on the same page and have the same game plan.
Yeah. Typically, my response is the same. Remember that workers' compensation in an accepted case, meaning that workers' comp is not denying you got hurt on the job, will pay for 100% of the medical bills, and you will be left with no money out of pocket. The other thing I want to discuss in all of this is you cannot sue your employer. We are by no means saying that if you were hurt on the job, can you sue your employer? There has to be another party at fault, and that party cannot work for your job. So, Chris, what's an example of a time where an individual, is injured on the job and wants to sue their employer, but unfortunately can't?
Well, that would be, for example, if the employer has committed some negligence which led to the accident. If an employee or a supervisor did something negligently that resulted in the injury of the employee. For example, let's say the employee is a forklift operator and another employee who is also operating a forklift does so negligently causing a collision. The employee cannot bring a civil lawsuit for negligence against the employer or the coworker. That is barred by the exclusive remedy provision. And your only recourse is workers' comp, even though a coworker, fellow employee did something negligent that caused your injury.
Yeah. And like we said, this is a very interesting and a very difficult area of the law. So please do not hesitate to contact us here at Gerber and Holder if you have a question about your workers' comp and personal injury claim, and we'd be more than happy to discuss anything with you. Thanks a lot, Chris.
Thank you.